Forget the tabloid coverage. Forget the feuds, the palace sources, the sympathetic profiles. Forget every commentator who spent 5 years telling you this was a family falling apart. Here is the question none of them thought to ask. What happens when a member of the line of succession to the British throne simultaneously declares financial independence from the crown, sues the state's own security committee, takes a commercial tour of a Commonwealth realm where that same crown is sovereign while his wife earns commission on every outfit she wears to a children's hospital? That question has no answer in British law. That is the story. By the time we reach the final revelation today, you will understand something that 5 years of royal coverage has completely failed to tell you. This is not a family dispute dressed up in legal language. This is a constitutional crisis. Every institution involved the Home Office, Buckingham Palace, the Court of Appeal, the Prime Minister's office has been handling it piece by piece, in isolation, hoping nobody joins the dots. Today, we join the dots. Give me 80 seconds. 5 revelations. Revelation 1. The single most important term of the Sandringham Summit was never written down. What that absence means legally. Revelation 2. The body that stripped Harry's security has 2 royal household representatives sitting on its board. They were in the room when it voted. Revelation 3. The Australia tour presented as charitable was simultaneously a commercial operation. Meghan earned personal commission on every outfit. Harry may be about to ask the British taxpayer to fund the security for it. Revelation 4. The $135 million financial empire that was supposed to make all of this possible has quietly collapsed. The timeline of that collapse maps directly onto every legal and political decision since. Revelation 5. Under the Succession to the Crown Act 2013, Harry is still in the line of succession. His children are still in the line of succession. British constitutional law has no framework for what that means when the person in question lives in California, sues the government, and earns commercial income from royal identity. Nobody has answered that. Not one institution. Not one piece of legislation. Let's go. Point 13, January 2020. Sandringham Estate, Norfolk. 4 people in a room. Queen Elizabeth II, Prince Charles, Prince William, Prince Harry. They were there to negotiate the terms of the most constitutionally unusual royal exit in modern British history. 5 days earlier, Harry and Meghan had announced to the world unilaterally, without palace approval, without constitutional advisors, without any visible legal framework, that they intended to step back from senior royal duties and become financially independent. The announcement was a shock. The negotiation at Sandringham was meant to turn a shock into a structure. The publicly announced result: on the 18th of January 2020, the Sussexes would repay £2.4 million in Frogmore Cottage renovation costs. They would no longer use their HRH titles commercially. They would receive no public funds for royal duties. They would seek financial self-sufficiency. Those were the terms. That was the deal. Here is what nobody told you. The one term that mattered most to Harry, the security arrangement for himself and his family, was never committed to writing, not in the palace statement, not in any subsequent legal document, not in any filing that has ever appeared before any court. Harry has stated in his memoir and in subsequent legal proceedings that he left that summit believing his family's security would be maintained. Rave C, the Royal and VIP Executive Committee, the Home Office body responsible for protective security decisions, downgraded his protection within weeks of that meeting, not months. Weeks. 5 years of litigation followed. 2 court defeats. A judicial review dismissed at first instance. A Court of Appeal ruling in May 2025 R. Duke of Sussex v. Home Secretary 2025 EWCA Civ 548 upholding Rave C's decision. Then a pivot to direct political lobbying. Harry writing privately to Home Secretary Shabana Mahmood in October 2025 asking for a fresh review. A review that Rave C then agreed to conduct in December 2025. 5 years. 2 courts. 1 political letter. And the foundational question, was there a security commitment made at Sandringham in January 2020, has never been answered in law because it was apparently never written down. You are thinking, that seems like an oversight. I am not saying it was deliberate, but consider what it means in practice. When the most consequential term of a constitutional negotiation is not documented, neither side can prove what was agreed. One side can claim security was assured. The other side can act as if it wasn't. And the courts, when asked to resolve the dispute, have only the silence of an unsigned document to work with. The most important term of the Sandringham Settlement is a verbal agreement, if it was an agreement at all. But that is not the most damaging revelation. That one involves the body that made the security decision and who was sitting inside it when it did. Rave C. The Royal and VIP Executive Committee. If you have followed the Harry security case even casually, you have heard this acronym. What you probably have not heard, because the mainstream coverage treated it as a procedural footnote, is what sits at the structural heart of Ravesey. 2 seats on Raves are held by representatives of the royal household, the royal household, the institution Harry had just left, in acrimonious circumstances, after a public statement that sent shockwaves through Buckingham Palace, after a Netflix documentary, an Oprah interview, a memoir, and a series of legal actions that directly named and implicated that institution. When Ravesey voted in February 2020 to downgrade Harry's security, the decision that triggered 5 years of litigation, the royal household's own representatives were in the room. Harry's legal team argued this constituted a structural conflict of interest. They argued, in essence, that the institution deciding the security of a man who had just left the institution in public conflict with it, and who had subsequently accused it of serious failures in court proceedings, could not be considered an independent and impartial decision-making body. Court of Appeal, in its May 2025 ruling, upheld Ravesey's decision, but it acknowledged the judges used these words that the conflict of interest argument was of particular concern, not dismissed, not resolved, acknowledged as a concern, and then set aside. Let me put this slant plainly. A government committee with institutional membership from Buckingham Palace made a security decision affecting a man in legal conflict with Buckingham Palace. When that conflict of interest was challenged in court, the court said the decision could stand but agreed the structure was concerning, and then nobody changed the structure. As of December 2025, a fresh Ravesey review of Harry's security is underway. Same structural arrangement, same conflict of interest, same royal household representatives, same seats. Same committee, the story changed. Again. And it will keep changing until someone asks the question the Court of Appeal declined to answer directly. Should the royal household hold any seat on a committee deciding the security of someone in active legal conflict with the royal household? Total silence from Westminster, from the Home Office. From every reforming voice that has spent the last decade demanding accountability from institutions that judge cases in which they have a direct interest. Before we go to Revelation 3 and to the moment where the legal argument and the commercial operation collide in a way that neither lawyers nor commentators have properly examined, I want to take 30 seconds. This channel has no sponsors. No PR team telling us which stories are safe to cover and which ones will upset the wrong people. No advertiser pulling content because the subject matter is complicated. What we do is read the court filings, the government records, the published biographies with legal backing, the academic constitutional analysis, and we tell you what we found. Next week, we are going somewhere that nobody in the royal commentary space has been willing to go. We are going to the actual text of the succession to the Crown Act 2013. We are going to ask what it means legally, practically, constitutionally, that Harry and his children remain in the line of succession, while the commercial and legal architecture of their post-royal life continues to depend on their proximity to the institution they claim to have left. That piece drops next week. It will not stay up long, because the questions it raises are ones that certain institutions would prefer not to have answered in public. Stispers now. It is the only way to make sure you see it. Now, back to the case file, 14 April 2026. Melbourne, Australia. The Royal Children's Hospital Meghan, Duchess of Sussex, arrives at a children's hospital. She kneels beside hospital beds. She talks to children in wards. She holds hands. The cameras record all of it. It is, by any reasonable standard, a moving and genuinely compassionate visit. Nobody is suggesting otherwise. What nobody reported properly, what every outlet covering the tour either missed or declined to examine, is what was happening simultaneously on a commercial platform called One-Off. One-Off is an AI-powered fashion platform. Celebrities and public figures list their outfits. Fans can shop identical or similar items. The platform earns a commission per sale. The celebrity earns a share of that commission. Every outfit Meghan wore during the Australia tour, including the outfit worn to that children's hospital visit, and including the outfit worn to meet survivors of the Bondi Beach attack, was simultaneously listed as a shoppable product on One-Off, earning Meghan a commission of up to 25% per sale. The tour generated $51.6 million in media impact value in 4 days. That figure comes from data published by Launch Metrics and reported in Women's Wear Daily. Meghan's One-Off platform surpassed 1 million outfit views in the first 3 days. You are thinking, that is just influencer marketing. That happens all the time. Here is what makes this different. The outfit worn to a children's hospital visit was generating commercial revenue because Meghan was wearing it. Meghan was at the children's hospital because she is the Duchess of Sussex. She is the Duchess of Sussex because she married Prince Harry. And the commercial value of the Duchess of Sussex title, the entire basis on which one-offs traffic, the media impact value, and the shoppable platform revenue operates, derives from the royal institution that the Sandringham Settlement committed them to commercially separating from. The Sandringham Settlement explicitly prohibits the commercial use of their royal adjacent status. That is not contested. It is in the public record, but here is the deeper legal question, the one that nobody in the tabloid or even the serious press has asked. Harry is currently awaiting the result of a fresh RAVC security review, the review he requested in October 2025 after 2 court defeats. That review will assess whether he requires taxpayer-funded specialist security protection. The justification for that protection, the argument his lawyers have made across 5 years of litigation, is that his public profile, his position in the line of succession, and the genuine security threats that accompany them make case-by-case police protection inadequate. That argument depends on Harry being a public figure whose profile generates risk. But that same public profile, the one that generated $51.6 million in media impact value in 4 days, is simultaneously the commercial infrastructure that Meghan monetized on one-off. Can you argue to the British government that your public profile creates a security threat requiring taxpayer-funded protection, while simultaneously your spouse earns commercial income from that same public profile on a fashion platform? Think about that, because at the moment, RAVC considers Harry's fresh security request. The most recent evidence in the public record about what the Sussex public profile generates commercially is this: $51.6 million in 4 days, and more than 1 million outfit views, on a trip that a palace source described as being conducted with coverage as intense as an official royal tour. The $100 million, the number that made headlines in September 2020, the number that appeared in every article announcing Sussex commercial independence. Netflix, reported value $100 million to $135 million over 5 years. Add Spotify, reported value approximately $20 million. A podcast called Archetypes, 12 episodes. It's 1 season. This was the financial architecture of Sussex independence. This was the answer to everyone who asked how they would sustain a private security operation estimated to cost between £5 million and $8 million per year. A $14.65 million Montecito property carrying a reported $9.5 million mortgage. A global media operation. Legal teams across multiple simultaneous cases in multiple jurisdictions, and a lifestyle that sources in 2026 describe as requiring approximately $6 million annually just to maintain. The Spotify deal ended in June 2023. The platform's own executive, Bill Simmons, described the arrangement in terms that left no room for ambiguity. The Netflix deal, the foundational pillar, was restructured from a multi-year guaranteed arrangement into a far less lucrative first-look agreement. Meghan's cooking show, With Love Meghan, will not be renewed for a 3rd season. The As Ever brand's commercial relationship with Netflix has reportedly concluded. Here is the timeline detail that the financial press mentioned once and then moved on from. The Spotify deal collapsed in early 2023. The Netflix deal began its restructuring in the same window. The Mirror Group phone hacking trial, in which Harry testified as the first senior royal to appear in court in 130 years, ran through the summer of 2023. The Mirror Group verdict came in December 2023. It awarded Harry £140,600 on 15 of 33 complained of articles. The remaining 115 articles settled before full evidentiary testing. In January 2024, Harry withdrew his separate libel case against the Daily Mail's publisher, paying over £60,000 in their legal costs. In February 2024, he settled the remaining Mirror Group claims for substantial additional damages amount undisclosed. The story changed. Again, commercial income collapsed. Legal expenditure accelerated. Same 18-month window. And Norman Baker, a former UK government minister and Home Office analyst, not a gossip columnist, stated publicly, there was nothing else to come, nothing else to sell apart from themselves. At this point, it is becoming a bit of an Olympic sport. The multi-$100 million commercial architecture of Sussex independence was not a sustainable business model. It was a one-time liquidation of royal celebrity capital. Royal celebrity capital that, in structural terms, always going to have a finite market value. The market reached its verdict. 1 Spotify contract, 2 Netflix restructurings, 1 canceled cooking show, staff cuts of 2/3. The financial pressure this creates is not a tabloid angle. It is the explanatory framework for every subsequent decision. The RAVC lobbying, the Australia commercial tour, the one-off platform, the litigation settlements that closed cases before the full evidentiary record could be tested in court. Each of these decisions becomes legible the moment you understand that the financial foundation they were built on has substantially collapsed. I want to slow down here here for a moment, because behind every court filing and every legal brief and every Rave C committee meeting, there are people who have no public voice in this story. People whose lives have been directly changed by it. There are the journalists and the ordinary people caught in the Mirror Group hacking proceedings. Judge Fancourt, in his December 2023 ruling, found that Harry's close friends and romantic partners, people who never sought public life, who had no idea their phones were being targeted, were regularly the subjects of unlawful information gathering by Mirror Group journalists over more than a decade. They were hacked so that newspapers could write stories about a prince they happened to know. They received no public accounting because the full evidentiary scope of 148 complained of articles was sealed by settlement rather than tested in open court. Their stories, the actual human damage of industrial-scale phone hacking, exist in legal documents that are not publicly accessible. There is a public petition from Australians launched during the April 2026 tour from ordinary people experiencing genuine cost of living pressure, asking their government not to use any public resources coordination, security support, official facilitation for what was effectively a private commercial trip. The petition was not filed by palace loyalists or tabloid campaigns. It was filed by people who looked at the circumstances and reached a conclusion about fairness that the institutions involved were not prepared to reach publicly. There are the household staff. Reports in 2026 described the Sussex operation cutting its workforce by 2/3 from 16 full-time employees to 5. These are people who built careers around a project presented as financially sound and commercially sustainable. They had no role in the legal decisions, no role in the commercial strategy. They were simply people who went to work every day on something structurally unsustainable and who are now gone. Their names do not appear in any court filing. Their stories are not told in any documentary. They are the anonymous cost of every deal that collapsed. And then there are Archie and Lilibet, born British, holding royal titles under the terms of letters patent issued in September 2022, in the line of succession to the British throne. Raised in Montecito, California, with no guaranteed security in the country of their birth, with no formally resolved constitutional status in the institution to which their births legally connect them. They are 7 and 4 years old. They did not choose any of this. And the question of what the British state owes them, what protection, what recognition, what constitutional standing has never been asked in any court, any parliamentary debate, or any government policy document. They are the clearest human evidence that the question at the heart of this story has never been properly answered. Here is my verdict. Not a theory, not a media narrative. A conclusion built from primary sources. Point 3 in January 2020. Constitutional negotiation takes place at Sandringham. The most consequential term, security, is not committed to writing. Both sides proceed as if different things were agreed. February 2020. Rave C, with royal household representatives in the room, downgrades Harry's protection within weeks of the public deal being announced. No conflict of interest is formally declared or resolved. Point 2020 to 2023. The commercial structure, Netflix, Spotify, Sussex brand is built on royal celebrity capital, framed as financial independence. It generates real money. It also generates a structural dependence on maximum media exposure that is directly incompatible with the privacy framing used to justify the exit. 2023 to 2024, the commercial income collapses. The legal expenditure accelerates. Settlements seal the evidentiary record in case after case. May 2025, the Court of Appeal upholds Rave C's. Harry writes to the Home Secretary in October. A fresh review begins in December. April 2026, the Australia tour simultaneously generates charitable goodwill and commercial income via the one-off platform Every Outfit from every charitable engagement listed as a shoppable product. May 2026, financial pressure reports emerge. Staff cut by 2/3. The question of how the Sussex operation sustains itself financially has no clear public answer. Underneath all of it, Harry remains in the line of succession. His children remain in the line of succession. British constitutional law has no framework for any of it. The math doesn't lie. The PR does. Every institution involved has handled one piece of this in isolation. Rave C handled the security question. The courts handled the hacking cases. The palace handled the commercial boundary questions through public statements that carry no enforcement mechanism. The Home Office handled the lobbying letter through an administrative process. Nobody has asked the foundational constitutional question: what is the legal status of a non-working member of the line of succession who has declared financial independence, is suing the state's security apparatus, and is simultaneously earning commercial income from residual royal identity in a Commonwealth realm? No legislation answers it. No court has been asked to rule on it. No parliamentary committee has examined it. No government minister has publicly acknowledged that it exists as a question requiring an answer. That is not an oversight. That is a choice. And the choice to leave that question unanswered is itself a constitutional decision, with consequences that are only becoming visible now. Here is the question I want you to sit with, and I want your genuine answer in the comments, because I have read every legal analysis published on this case, and I have not found a satisfying answer anywhere. The Sandringham Settlement committed the Sussexes to financial self-sufficiency and prohibited the commercial use of their royal adjacent status. The settlement has no enforcement mechanism, no dispute resolution clause, and no independent verification body. It is, in legal terms, either a binding agreement or a public statement of intent, and 5 years later, nobody has definitively established which. The commercial tours, the fashion platforms, the security applications to a taxpayer-funded committee, the simultaneous claims of independence and institutional protection. If the Sandringham Settlement is legally binding, who is standing to enforce it and why has no one tried? If it is not legally binding, what exactly did the Queen, the Prince of Wales, the future King, and Prince Harry agree to in January 2020? And why does the palace continue to behave as if it is? Drop your answer below, because I think the people closest to this story already know the answer to that question, and the fact that it has not been stated publicly in any forum by any party in 5 years tells you everything you need to know about what the answer is.